Hi, I'm Shan Wu with an Undercover of Law hot take on the Manhattan District Attorney's response to Trump's motion to dismiss. Now, we had a little bit of a break, had some COVID issues. I'm fine, but my staff helping me all were out for the count for a bit. So we're back online, so it's good to see you. The presidential immunity decision that the Supreme Court put out has caused all sorts of mischief. And one of the rather unexpected ways this caused some mischief is that the moment it came out, Trump's attorneys seized upon it to try to make it apply in the state case where he's been convicted, which is the one brought by Alvin Bragg about the falsification of business records, the fraudulent cover-up that went on to conceal the fact that they were paying the money to actor-director Stormy Daniels to try and keep her quiet about the sexual encounter that happened. Again, nothing illegal about such a non-disclosure agreement. What was illegal about it was that they lied and falsifying the business records with the intent to help Trump in the election. Now, the reason that this was a little bit unexpected is because the presidential immunity case really goes to acts done while a president is in office, and it really applies mostly to the federal cases. This was a state case. So it's a pretty weak connection. How weak was it? Well, when I testified in front of Jim Jordan's House subcommittee on the weaponization of the federal government, they were actually focusing on attacking Alvin Bragg's conviction of Donald Trump. This is how weak this argument is. They didn't even bring it up. I wasn't even asked about it. Now, just for fun, I must show you one of the highlights of the testimony there, which was when Representative Jasmine Crockett was questioning me. And we'll just take a listen to that because it's great to listen to.
So typically, if someone has an issue with, say, what happens in court, do they then somehow hop from state court all the way to the federal legislative branch, or is there a different process in which you are supposed to be able to explain any issues you may have?
The process would be the judicial appellate process, holding aside the issue of state versus federal.
Oh, interesting. Okay. All right. So normally people don't get convicted on a state level and somehow end up litigating the issue on the federal level in the legislative branch. Is that correct?
Yes.
Okay. All right. So something is different about what's going on today. I just wanted to clarify because I thought I was living in the upside down for a second.
So had to play you that because it's a great example of how you use congressional testimony in a way that you ask leading questions. And I, being the helpful witness, was basically doing the yes, no. Her point on that is really great, which is what the hell is Congress doing trying to look at the state prosecution? Holding aside the federal-state dichotomy, it's also an example of a federal legislative branch trying to interfere with a state executive function. But let's take a slightly deeper dive into exactly how the presidential immunity decision could affect Trump's conviction. So it boils down to, well, first, let me point out that it's a 62-page response, and I printed on both sides of the paper to save trees. In there, you can really boil it down to two things. One was the testimony by Hope Hicks, and two was the Ethics in Government Financial Disclosure Act that Trump had to file. So on Hicks, what Trump's attorneys want to argue is that because she had conversations with Trump taking place within the White House, because she was on staff, that transforms all that into an official act, and therefore that piece of the evidence has got to get kicked out because he's immune as to official acts. The second piece of evidence they want kicked out is the financial disclosure form that Trump made. So two big problems with those arguments. First, at the outset, as the Manhattan DA's office pointed out, as a legal matter, Trump's attorneys, unsurprisingly, failed to preserve the argument. They kind of fell down on the job. You really have to make objections at the right time to, quote, make your record for appeal. They didn't really do that on the presidential immunity issues, and probably because nobody thought that the Supreme Court was going to issue this terribly bogus, overbroad ruling and basically invite this kind of legal mischief to be used. They did timely object on the Hope Hicks testimony, and the judge overruled it, so it's preserved for appeal. Here's why that testimony is not going to be an issue under the immunity ruling. First of all, she's talking about things which are obviously unofficial acts. All of this was an unofficial act. It happened before he was president. Second of all, let's use common sense. The idea of blanket presidential immunity, which is really what the Supreme Court has done, even though they would say it's not a blanket immunity, means that anything that the president does, this is the emperor theory, is completely immune from prosecution. The mere fact that she's talking to him when he's president of the United States and they're in the Oval Office, that common sense tells you can't transform everything that happens there in that conversation or anything else to be an official act. She's talking about something that happened a long time ago. Let's say a president were to admit to a crime that happened ages ago. That doesn't mean his conversation about it now is an official act. So that's the common sense point. The legal point is going to be that the particular communication they're having does not go to some act that he had to perform. So that's why that's going to be a loser argument. The Ethics in Government Act issue, which is the financial disclosure, is also going to be a loser argument because in the Supreme Court's decision on immunity, they carved out anything that is already of a public record. And those disclosure forms are of a public record. And they go to private finances, not some sort of official act, some sort of official finances. So that's two reasons that's going to be out of the question. A third reason why the financial disclosure form should be dismissed as an argument is that it doesn't apply just to the president. I mean, it applies to numerous government officials. So those two should be very weak. There's also an issue about some of the tweets that he'd done, the argument being, oh, Trump's official account, his tweets rather, were all official tweets. That's also going to go by the wayside because, again, the court had said if something is publicly disclosed and those tweets are going out to millions of people, that can't fall under this immunity carve-out issue. Now, even if the trial court or an appellate court were to find that, one, they properly preserved this, and two, that somehow these pieces of evidence, Hicks, the financial disclosure, were somehow implicated in the Immunity Act, it would still not cause the conviction to be overturned. And the reason for that is something called the harmless error analysis in the appellate courts. And that's the recognition that mistakes happen at the trial level. Something upon a objective third-party review by the appeals court might say, oh, that was wrong. That piece of evidence shouldn't have come in. Prosecutor shouldn't have been allowed to say that. But the mere fact that you just find a single error does not wipe out the entire conviction. It has to be analyzed in the whole of the record. And the harmless error doctrine is, yeah, that was an error, but it was harmless. It doesn't destroy the case. So as the Manhattan DA's office put very succinctly here, the evidence that's at issue here, Hicks's testimony, the ethics in government financial disclosure, even the testimony of another aide, Madeline Westerhouse, which they failed to preserve because they didn't object about the right issues. Even if you took all that evidence and the tweets and said, oh, it was a mistake to let it in, it runs afoul of what the high court said about immunity because these were somehow official-ish acts. Even then, as the Manhattan DA's office put it, it's just a sliver of evidence, meaning all of the other evidence that came in, the paper records, testimony by Stormy Daniels, Michael Cohen testimony, all those things present a big, overwhelming amount of evidence that shows the guilt. So even if you took these and cast them out, it would still be harmless error because those small slivers of evidence couldn't possibly have tainted the entire conviction. So that's the legal analysis of why this is going to go nowhere. But to a bigger picture, it really shows you just the kind of bad effect that this Supreme Court is having. So first of all, they've really made it nearly impossible for any future president to be prosecuted based on something that they did it. You can tell just by the complexity of this state case, which really had almost nothing to do with the president's official acts at all. It's such a stretch to try and make it fit in there. It's still going to cause a lot of hoops for the prosecutors to jump through to preserve this conviction. But that's not even the worst part. Future prosecutors are going to have to live with this Supreme Court decision. So even before they get to trial, they're going to be fighting their way through these questions. What's an official act? How do you define that? Who was talking to who about what? When? Was it in the White House? All those things make it so hard to bring a case in the future. And I think Justice Neil Gorsuch had said during the oral arguments about the immunity case that they were, quote, writing for the ages. Well, he was right about that. For future ages, they've basically given presidents complete immunity. And for Donald Trump, they've made it take ages for him to be held accountable. Much, much longer and more complex than the process would take for anybody else. Okay, so that's it. Nice to be back. And please keep those comments coming. They're really helpful to read them. And we'll talk again soon.
Love this video? Make sure you stay up to date on the latest breaking news and all things Midas by signing up to the MeidasTouch newsletter at MeidasTouch.com/newsletter.